This conference will now be recorded.
Hi, it's Jessica Miller-Merrill with Workology. Welcome to this webinar titled Understanding the H-1B Visa and Alternative Employment Immigration Options. We are here today with Jason Finkelman. He's an immigration attorney at Jason Finkelman, Attorney at Law. Jason has assisted hundreds of companies, investors, business owners, executives, professionals, skilled workers, students, and families with obtaining employment visas, lawful permanent resident or green card, and U.S. citizenship. So he has a vast amount of experience. He's a friend and a great speaker, and also a contributor here to the Workology site. And so I'm excited to have Jason join us for the next 45 minutes or so and talk through the H-1B visa and alternative employment immigration options for you. So take it away.
Thanks, Jessica, and I really appreciate you having me out, and thanks to Workology for hosting this webinar. As Jessica said, the focus of my practice is really on employment-based and family-based immigration law, and this webinar is going to primarily tackle the one particular visa, the H-1B visa, as mostly, and as well as some other alternative immigration options for employers, as well as foreign nationals who are seeking to work in the US. So as we go through this is going to be a very general overview. And I expect as we go through this, people may have questions, and you'll see here my contact information. If you have any questions, you can contact me here, and you'll see that at the end of the presentation. But I'm going to try to be as comprehensive as possible on a large or big area of immigration law. So I hope everyone finds this useful. And I think a good place to start really is to take a step back and understand the way the U.S. immigration system works. And the way the U.S. immigration system works is it's really divided into two hemispheres, what's called the non-immigrant visa and the immigrant visa. The non-immigrant visa are all temporary visas to the U.S., and there's many different types of non-immigrant visas, and they range from letters A to letters U. And each one of those letters has different eligibility requirements. Each one has different lengths of stay that a person can come and stay in the US. Some of those non-immigrant visa options provide for work authorization, some do not. But built into each one of these non-immigrant visas is this temporary nature to them, and that the foreign national who's coming to the US, whether to work or not to work, intends to return back to their home country. On the other side, the other hemisphere is what's called the immigrant visa, which is the same thing as a green card or lawful permanent residence in the US. And an immigrant visa lets a person come to the US and stay permanently in the US. The focus of this presentation is primarily going to be on the non-immigrant visa options. We'll talk at the end very briefly about immigrant visa options. But through all those letters, each one, again, having different eligibility requirements and different lengths of stay, I want to start first by tackling the H-1B visa. And that visa, the reason why we're tackling it here today is because it's very timely, okay? And the H-1B visa is a work authorized visa. It allows a foreign national to come to the US to work for an employer, a US employer, for up to 3 years initially, plus a 3-year extension thereafter for a maximum of 6 years, in a job that normally requires a bachelor's degree to perform. So jobs in the tech sector and engineering sectors, even marketing and operations jobs. Those are jobs that normally require a bachelor's degree. But a job, let's say pouring coffee at Starbucks, or a job doing janitorial services, aren't jobs that typically require a bachelor's degree. So those are jobs that would not be H-1B visa eligible. So the first requirement is that you, the foreign national, have a US employer who's going to sponsor you in a job that requires a bachelor's degree or higher to work in. The second requirement is that you, the foreign national, have a bachelor's degree that relates to the position you're going to be working on or working in. And this is a really hot button issue right now in the adjudication of the H-1B visa petition, because U.S. Citizenship and Immigration Services, USCIS, the body that adjudicates H-1B visa petitions, want to see that the foreign national who's applying for this H-1B visa has what's called a theoretical and practical knowledge base that they gain from their course of study that are being applied to the job duties and functions that they're going to be performing for this U.S. employer. So, by way of example, if a foreign national is coming to work in a job that's a marketing job, but they have a degree in chemistry, there's going to be some issues there in proving to USCIS that a foreign national in their course of study of chemistry learned the skills that are needed to perform this marketing job. That's not to say that the degree has to be an exact match for the position, but in this current strict immigration environment, it's really critical to be able to show how in almost every single course of study that person took, they can apply the knowledge that they learned in that course of study to the job duties they're going to be performing. The other requirement, and we'll get to this here in a slide here in a little bit, is that the employer must pay a required wage for the position. But that's generally the H-1B visa, the requirement. One, that the job has a bachelor's degree, and two, that the foreign national has a degree that relates to that position. It requires a U.S. employer to sponsor you. The H-1B and almost all of the non-immigrant visa options we'll talk about in this presentation do not allow for a person to self-sponsor themselves for a visa. So you must have a U.S. employer that is sponsoring the foreign national to come work in a specific job and at a specific location. The USCIS regulations do not allow a foreign national to come work from home or work for multiple employers. They have to be coming to work at a specific job site, and they have to be coming to work in a specific job title doing specific job duties. They can't be a jack of all trades and doing many different things. They have to be performing a sole bachelor's degree level type of position. The employer is required to pay, as I said earlier, a required wage for the position. So the way this process works is really at step one, the U.S. Department of Labor comes in and says, okay, we, the U.S. Department of Labor, are going to tell you, U.S. employer, what you must pay this foreign national at a minimum for this H-1B visa position. And so the U.S. Department of Labor has an online library of basically all job occupations. And they say, based on what this job occupation is and what this job category is, and based on the geographic area where this foreign national is going to work, we will say what the minimum salary is for that employee. And you, U.S. employer, must agree in what's called a labor condition application to pay that foreign national that required wage. So, for example, and I'm totally making this up right now, the U.S. Department of Labor may say that in San Francisco, a software developer at a minimum makes $80,000 a year. Therefore, the U.S. employer must agree to pay at least $80,000 for that foreign national in this H-1B petition. Failure to do that is a non-starter. You can't move forward with the H-1B visa petition because it would be denied. Okay. The employer must pay for all of the H-1B visa costs. One of the questions I get often is usually from a foreign national student or someone outside the U.S. saying, hey, I found a U.S. employer. We've got an H-1B visa qualifying job. They want to hire me for the position. They'll sign whatever documents need to be signed, But they say, we don't want to pay for it. If you foreign national, want this H-1B visa, you pay for all the costs. Unfortunately, that's a no-go. And oftentimes employers just don't know that they're required to pay that wage. So anyone who's listening to this shouldn't be put off or intimidated if and when that situation arises, because it's quite common. And it's okay to say to the employer, unfortunately, I, foreign national employee, am not legally allowed to pay for any of the costs, whether it's the filing fees, the application fees to USCIS, or legal fees to an attorney. You, U.S. employer, are required to pay those fees. And also, the employee must be paid for this position through the payment from the employer. They cannot be paid from a third-party source. The payment for the salary should be coming directly from the employer. So let's talk for a second here about the H-1B visa movie, as I call it. So the H-1B visa has a cap on the amount of visas that are issued each year. And that cap is 85,000. It's the only non-immigrant visa category we're going to talk about that has a limit on the amount of H-1B visas that are issued annually. And so each year, U.S. Citizenship and Immigration Services, USCIS, on April 1st, makes 85,000 H-1B visas available for everyone in the world to apply for. If that visa is approved, it becomes active to use on October 1st. It's good for 3 years initially. And again, a 3-year extension thereafter is available for a maximum of 6 years. So April 1st, U.S. employers file those H-1B visa petitions with USCIS, not earlier, not later, and I'll explain why here in a second. And if that visa petition is approved, the foreign national can begin working in the U.S. on October 1st, okay? What happens, at least in the last 6 or 7 years, is on the very first minute of April 1st, USCIS receives in excess of 85,000 H-1B visa petitions. So when they do that, they say, uh-oh, we've got a problem. We got way too many visa petitions for the only 85,000 available visas. We've got to make a public service announcement and tell employers, we got way too many visa petitions. We're shutting down the H-1B visa program usually after the first week of April. We're going to take all those visa petitions that we received, those H-1B visa petitions we received, let's say in the first week of April, and we're going to put them in a computer-generated lottery system. We're going to let a computer select at random the 85,000 H-1B visas that we'll then hand process to see if they're approvable. Those that are not selected in that lottery are returned back to the employer with their filing fees, and employers are told, sorry, you weren't selected in this lottery. Try again another year, okay? Now, it's a completely fair lottery. There are lots of rumors all over the internet about, or just misinformation about ways to get a leg up in the lottery. There is no way to get a leg up in the lottery. It's a completely fair lottery. It doesn't matter if you're working for Facebook or Google or a one-person startup. It doesn't matter your nationality. It doesn't matter how much salary you're being paid. It's just a fair lottery. Now, the only leg up that some people have in this lottery is individuals that have a U.S. master's degree or higher. Individuals that have a U.S. master's degree or higher, out of the 85,000 H-1B visas, USCIS sets aside 20,000 H-1B visas and runs a lottery first with individuals that have a U.S. master's degree or higher. Those that are not selected in that lottery are given a second chance to play with the remaining 65,000 H-1B visas. So those individuals sort of get 2 bites at the apple or 2 plays in the lottery, okay? Now, April 1st, today may be the end of, we're nearing the end of 2018, and April 1st may seem a bit of a ways off, but the time to start preparing H-1B visa petitions for US employers is right now, and certainly no later than the first week of March. Why? The process of preparing a comprehensive H-1B visa petition can take some time. And again, these H-1B visa petitions need to be into USCIS on April 1st. Additionally, as we talked about in the previous slide, the labor condition application, which is what's filed with the Department of Labor, is really the first step in this process. It's a prerequisite to filing this H-1B visa petition. And that labor condition application needs to be certified by the US Department of Labor before the H-1B visa petition can go into USCIS. And that labor condition application can take, in some cases, 7 to 10 days to get certified. And so employers who are waiting till mid-March run a very high risk of not getting that labor certification certified, not timely preparing the comprehensive H-1B visa petition, and not having that H-1B visa petition into USCIS on April 1st. And failure to do that likely means you will miss the lottery. So those who may be listening to this now, the time to start preparing is right now. Now, we're in the end of 2018, and very recently, in the past couple weeks, there has been some proposed regulations that would dramatically change everything we've just talked about here. And those proposed regulations are about revising how this lottery system works and revising how the process of selection of these 85,000 H-1B visas will be conducted. Whether these will be coming into play in 2019, not sure, but it certainly is something that I would suspect would be coming on the horizon in the coming years. Generally, this proposed regulation says that rather than having all these employers file their H-1B petitions on April 1st and conducting lottery, USCIS would have a pre-registration system that would allow US employers to simply register their company and the individuals they want to sponsor for H-1B visas, and then conduct that lottery before the actual petitions are filed to let employers know whether they are eligible to file an H-1B visa petition for that particular beneficiary or not. Once they conduct that lottery, there would be again, this is proposed, a 60-day window for employers to file their labor condition applications and prepare their H-1B petitions and file those H-1B petitions. And then they would revise the selection in the lottery to run what's called the master's cap first to see who is selected in the master's cap. And if those aren't, if they've fulfilled and selected all of the master's people, anyone else who has a bachelor's degree would be eligible for an H-1B petition. So kind of reversing the selection in the lottery. Again, these are proposed regulations right now. We don't know if they're going to be in play in the next, let's call it 4 months for the 2019 H-1B Visa Lottery. But it's likely that could be the case in future H-1B visa cap lotteries. Now, there are certain H-1B visa employers that are exempt from this 85,000 H-1B visa cap, meaning there is an unlimited amount of H-1B visas available for these employers, and they're not subject to waiting till April 1st or October 1st to get the visas. They can apply at any time during the year. Those are college or university employees, so any foreign national who may be working at an institution of higher education is usually exempt from this H-1B visa cap. Same thing with nonprofit institutions that may be related to an institution of higher education, such as a teaching hospital or certain nonprofit or government research organizations. Anybody who may have an opportunity to work at one of those organizations should probably reach out and speak to an immigration attorney to see whether, in fact, that institution qualifies as a cap exempt organization before filing that H-1B visa petition. Additionally, those individuals that are filing an extension of their H-1B visa or changing employers are no longer subject to the H-1B Visa Lottery. Essentially, once a foreign national gets through that H-1B Visa Lottery, has been selected and approved, they're not subject to having to go through that lottery again. So if they go to extend their H-1B visa for an additional 3 years after their first 3 years, they're not subject to the H-1B Visa Lottery. And same thing if a foreign national is changing to a different employer. Yes, that new employer must file a new H-1B visa petition, but it can be filed at any time during the year, and it is not subject to that H-1B visa cap lottery. So here's generally how the H-1B visa process works, okay? So right now, people are beginning to file their labor condition applications, or employers are filing their labor condition application, the LCA. That's the promise to the U.S. Department of Labor by the employer to pay the foreign national the required wage. And that's something, again, employers should be doing now because of the time it takes to process, and that needs to be certified and in your hand before the H-1B visa petition can be filed on April 1st. Second step in this process is on April 1st, the H-1B visa petition is filed. Typically, U.S. employers find out whether the petition was selected in the lottery in about 3 to 6 weeks after April 1st. This past year, I would say in my experience, we were finding out closer to end of May, most of June is when we were finding out who was selected in the lottery and who was not. Thereafter, it usually takes about 3 to 5 months to find out when that petition is approved, if it was selected in the lottery. That said, this past year was the first year that we saw petitions, finding out if petitions were selected in the lottery, taking longer than October 1st. So as we talked about earlier, usually in previous years, we would find out in, let's say, June that the H-1B petition was selected in the lottery. And then sometime in the late summer, we would find out if that petition was approved. Let's call it August or September. And then that person got their approval notice and on October 1st either changed to H-1B visa status or got their approval notice and went to the consulate in their home country and got that H-1B visa stamp in their passport. This year, or this past year, was unusual in the sense that many attorneys and many employers nationwide were not finding out if H-1B visa petitions were approved until October, November, December. In some cases, employers still haven't found out if those petitions have been approved. So processing times are increasing based on this past year, and employers should be aware of that. Now, one of the questions I typically get is whether or not to premium process an H-1B visa petition. Premium processing is an optional program through USCIS that allows employers to pay an additional $1,410 to get an answer on their petition within 15 days, as opposed to the many, many months it can often take to get an answer on a petition. Typically, I advise employers, except in some exigent circumstances, that it's not worth their money to file with premium processing when they file their petition in April 1st, because even if they got an answer in June or July or August, it does not let that foreign national come to the US any quicker to work. They're still subject to that October 1st start date. Additionally, one of the rumors I often hear is that paying that additional premium processing will give foreign nationals or employers a leg up in the lottery. And that is just an urban legend. That's completely false. It does not give any leg up in the lottery at all. Now, in previous years, as employers would get closer to that October 1st date and not yet hear back from USCIS on their pending selected H-1B visa petition, some employers opted to pay and upgrade their pending petition with premium processing to force USCIS to give them an answer quicker so that that foreign national could begin working on October 1st. Currently, USCIS has temporarily suspended premium processing, so that option is not available to US employers. However, that could be the case sometime in the future if those petitions are pending and the employer wants to quickly get an answer on a pending H-1B visa petition. Now, many foreign national students who are here in the US typically are here working under something called optional practical training, OPT. And many employers have foreign national students who are working for them currently on OPT. Optional practical training, OPT, allows foreign nationals to get a work authorization card, an employment authorization document that allows them 12 months of lawful work authorization, typically after they've graduated, to work for an employer that relates to their degree that they have. Oftentimes, US employers have a foreign national employee who's working for them on an employment authorization document or an EAD card through OPT. And that employment authorization document sometimes expires before that October 1st date. And I'll give you a sort of illustration of this in the next slide here. But what used to happen is if, let's say, an employer filed an H-1B visa petition for a foreign national on April 1st, and that foreign national's EAD card expired sometime in the summer, let's call it July, it used to be that USCIS said, well, if the petition was selected, the H-1B petition was selected and approved, that person can continue working with their OPT only until July, and then they have to go home, but then they can come back in October. Well, that didn't really make a lot of sense. So USCIS put in this provision called the H-1B cap gap extension, which essentially says, look, if you, US employer, are filing an H-1B petition for a student who's currently working for you on their OPT EAD card, and that petition, that H-1B petition, has been selected in the lottery, that foreign national student can take the receipt notice that says their H-1B petition was selected in the lottery to their school and have their work authorization through their EAD card automatically extended all the way until October 1st to allow them to continue working here in the US with their OPT EAD card. And then on October 1st, if that H-1B visa petition is approved, they would change their status to H-1B visa status. Here's an illustration of that to give you a sort of example. So if we say hypothetically that this student here has an employment authorization document, an EAD card, that expires July 25th, 2019, and their US employer has filed a H-1B visa petition for them on April 1st, 2019, and they find out that that H-1B visa petition was selected in the lottery, their employment authorization is automatically extended from July 25th, 2019, all the way till October 1st, 2019. If that H-1B visa petition is approved, then on October 1, 2019, they would change status to H-1B from F1 student to H-1B. And that's kind of how this works. And going back one slide here for a second, if the H-1B petition is not selected in the lottery, or thereafter the employer revokes the H-1B petition, or the H-1B is selected in the lottery and then is denied, the extension of their employment authorization in that cap gap extension there ends at that point. Now, individuals who are in the US and have been selected in that H-1B visa lottery, as we talked about before, can port or move to a new US employer. So foreign nationals are not subject to being tied to that US employer that sponsored their H-1B visa indefinitely. And in fact, like I said earlier, once you're selected in the lottery, you're not subject to going through that lottery again. And that foreign national can change to a different employer at any time. That new employer would have to file a new H-1B visa petition, pay all the fees all over again, but they're not subject to going through that lottery. Now, if a U.S. employer terminates that H-1B visa employee or that H-1B employee quits, currently the U.S. immigration laws allow for a 60-day grace period to allow that H-1B visa employee to find a new employer. So during that 60-day grace period, not only does that H-1B employee have to find a new employer, but that new employer must file the H-1B visa petition with USCIS during that 60-day grace period. If the foreign national cannot find a new employer during that 60-day grace period, that's okay, but that foreign national should prepare to wind up their affairs and go home. Thereafter, they can find a new US employer at any time who's going to file a new petition for them, and then they can get that new H-1B visa stamped in their passport at their home country and come back and work for that new employer. But changing employers after a termination or after an H-1B visa employee quits, there's a 60-day grace period to change employers and remain here in the US. Now, the reality of the H-1B visa, and especially over the last 6 or 7 years, is that most people and most US employers are not going to get all of their H-1B visas for all of their employees. By way of example, in 2017, for 85,000 H-1B visas, USCIS received in excess of 190,000 H-1B visa petitions. So mathematically, employers and foreign nationals had less than a 40% chance of getting an H-1B visa for their foreign national employee. So if foreign nationals find out they're not selected in the lottery, and if US employers find out they're not able to get the H-1B visa for the person they seek to hire, there are other alternative non-immigrant visa options. And going back to the very first slide, there are many different types of non-immigrant visa options. What you're looking at here is not an exhaustive list, but it's just some of the more popular visa options that U.S. employers utilize for hiring foreign nationals. If you have questions on this, as always, you can contact me to talk about these or any other options. But I wanted to talk about these very briefly and very generally so that employers and foreign nationals can get a good understanding of the alternatives if an H-1B visa is not available. So the first option we'll talk about here is called the L1A intra-company transferee visa. And the L1A visa is available for foreign nationals who are working in an executive or managerial capacity outside of the United States for 1 out of the last 3 years before they make their application for an L1A visa, for a foreign company that is related to a US company, either via a parent subsidiary relationship, an affiliate, a branch relationship. If there's that relationship between these two companies, the US company can transfer a foreign national employee to work who has been working in a managerial or executive capacity to also come to the US and work in an executive or managerial capacity as well. Typically, for companies that have offices around the world, if they're not able to get an H-1B visa for that foreign national, they will often say, sorry, we tried, your H-1B visa petition wasn't selected in lottery. How about you go work outside the US for our affiliate, subsidiary, branch office in, making it up, Singapore, Canada, Mexico, China, Brazil, and work for 1 year in a managerial or executive capacity. And what they mean by managerial or executive capacity is not necessarily by title, but by the functions, managing other employees, performing executive functions. If after 1 year of doing that, the US employer can then transfer that foreign national to the US to also work in an executive or managerial capacity. The visa is good for 3 years initially, plus two 2-year extensions for a maximum of 7 years. There's no caps on these visas. There's no timing on when to apply. And again, this applies for all of the visa categories you see here in front of you. None of these have caps on them like the H-1B visa. None of them have time periods in which you can apply. They can be applied for at any time during the year. But the L1A is a very versatile option for those employers that have offices outside the US or related entities outside the US and seeking to transfer executive or managerial employees. The E1 and E2 visa is for only certain foreign nationals from countries that have a treaty agreement with the US who are coming to the US to either engage in substantial trade or make a substantial investment in a US entity that thereafter they're going to run. The first issue with the E1, E2, like I said, is that there's a treaty between the foreign country and the US. Currently, countries that are not eligible for the E1 or E2 because there is no treaty agreement between the US and that country are major countries like China, India, Brazil, Russia, a whole host of other major countries are not eligible for the E1 or E2 because there is no treaty agreement. And you can Google whether there's a treaty agreement between the US and your home country to see if you're eligible for the E1 or E2. If you are, the E1 is for foreign nationals from that country who are engaging in what's called substantial trade between their home country and the US. And the E2 is for foreign nationals that are coming to make a substantial investment in a US entity that thereafter they're going to run. The first question I usually get on this is, well, Jason, what's a substantial investment? And while the law says that, substantial is proportional to what the type of business is you're going to be running. So, if you're coming to run a food trailer truck, the investment is much lower than if you're probably coming to the US to start a semiconductor fabrication facility. But generally speaking, the closer we're sort of seeing in trends right now, the closer that a foreign national is investing to, $100,000, the more USCIS tends to think that that is a substantial investment. Now, that's not the law. It doesn't have to be $100,000. Nothing in the law says that. But usually USCIS wants to see something substantial there so that they can see the company has enough to hire its employees, get its equipment, pay for its electricity, all the regular sort of things that an employer needs to get their business up and running. The O1 visa is for foreign nationals of extraordinary ability who are coming to work in the fields of arts, science, business, education, things like that. The O1 visa requires a U.S. employer, again, to sponsor a foreign national who can demonstrate that they have reached the top of their field through 9 or 10 different categories. And again, you can Google the 9 or 10 different categories. But they're things like winning awards in your field of expertise, speaking at major conferences, having your work published in major media or journals, having your work cited in major media, radio, television, major newspapers, being invited to be the judge of other people's work, working for prestigious organizations. If the foreign national can demonstrate at a minimum, three of those 10 or 9 or 10 criteria, the U.S. employer can sponsor that foreign national to work for the company in their field of extraordinary ability. That visa, again, can be renewed indefinitely, so long as that foreign national, like we talked about earlier, can demonstrate what's called non-immigrant intent to return back to their home country. And going back for a second for the E1, E2, same thing, that visa can also be renewed indefinitely in 2 or 3 year increments, so long as the foreign national can demonstrate with each extension of that E1, E2 visa that they intend to return back to their home country. The next visa category, the TN visa, is only for Mexican and Canadian professionals that are coming to work in certain occupations. Again, you can Google all of the occupation categories that are available for Mexican and Canadian professionals. It's a long list. There's hundreds of professional occupations in there. But so long as there's a U.S. employer who's sponsoring a Mexican or Canadian foreign national in one of those occupations, and the foreign Mexican or Canadian foreign national usually has a degree in that professional area, that U.S. employer can sponsor a Mexican or Canadian foreign national for a TN visa. They're also issued in 2 or 3 year increments indefinitely, so long as that TN visa holder can prove their non-immigrant intent to return back to their home country. Lastly, the E3 visa is only for Australian nationals, and the requirements are actually quite similar to the H-1B visa in the sense that it's for an Australian foreign national who's coming to work in a professional occupation. That foreign national has a bachelor's degree at a minimum to work in a professional level job. There is no April 1st or October 1st timing on that. There is no cap on the E3 visa as well. So that's very sort of general understanding of some other popular non-immigrant visa options. Again, there are other non-immigrant visa options available for lots of different people. If you think you have any questions or if you have questions on these or any of those other visa options, you're always welcome to contact me on that. Lastly, we've talked all about the non-immigrant visa options, especially the H-1B visa. And at the beginning, I talked about the immigrant visa category. So I want to talk very briefly here just to give you a very general, complete picture here of how this all works. But the immigrant visa or U.S. permanent residence can be obtained in one of 3 ways. Either A, through family, if a U.S. citizen or a U.S. lawful permanent resident is marrying a foreign national, or for U.S. citizen fathers or mothers looking to bring over children, or brothers and sisters or parents. There's a process to do that and bring over foreign national family through U.S. permanent residence. On the employment side, generally speaking, the U.S. government will make employers go through a test of the U.S. labor market before being able to hire foreign nationals on a permanent basis in the U.S. This process, known as the labor certification process, basically is the U.S. government saying to a U.S. employer, we want you to prove to us, the U.S. government, that there are no qualified, able, willing, or available U.S. workers who can do what this foreign national you seek to hire on a permanent basis can do. And we, the U.S. government, U.S. Department of Labor, are going to make you, U.S. employer, go through an active recruitment campaign to post ads in major media, radio, television, newspapers, online, in job sites, to prove to us that you've actively tried to recruit a U.S. worker to do the job of this foreign national. If through that recruitment campaign, you can prove to the U.S. Department of Labor that there are no qualified, able, willing, or available U.S. workers who can do what this foreign national does, we will approve or certify this labor certification and then allow that foreign national to go through a multi-phase process of filing for their U.S. lawful permanent residence or green card. So it's a multi-phase, multi-year-long process to get an employment-based green card for a foreign national. Again, that's a very oversimplified explanation of that. There are different categories, different processes in which a foreign national can obtain U.S. permanent residence through employment. For other questions on that, you can call me or email me. I'll post that information here in the next slide. But really quickly, lastly, the other option is what's known as the EB-5 Immigrant Investor Visa Program that allows foreign nationals to currently, emphasis on the word currently, either invest $1 million personally into a U.S. entity that's going to create jobs for 10 U.S. workers, or $500,000 personally into certain targeted areas of high unemployment that's also going to create jobs for 10 U.S. workers. These are different projects that a foreign national can invest in, and over several years obtain permanent residence that way. Again, very general explanation of that. If you have other questions, you can contact me. But that's generally the overview of the H-1B visa, of some of the other non-immigrant visa options that are available for both U.S. employers and foreign nationals, as well as some of the options for obtaining U.S. lawful permanent residence. These issues with immigration, especially in today's highly scrutinized, tight immigration environment, are always nuanced. Nothing is ever black and white. So I encourage you who are listening to feel free to reach out to me through any of these sources you see here in front of you if you have any questions. I'm always happy to answer questions. I appreciate you guys giving me some of the time. Again, I want to thank Jessica. I want to thank Workology, and I look forward to hopefully speaking to all of you again soon.